Thank you very much. What if you were the victim of a crime and you were prevented from testifying against your perpetrator because of the operation of the rules of law? Persons with intellectual disabilities are often prevented from being able to testify in court because there is a presumption that they are incompetent witnesses to testify in court. My research analyzes the application of rules of evidence that govern competency assessments to persons with intellectual disabilities to find out whether or not they actually serve to prevent them from testifying in court. In doing this, I focus mainly on persons with intellectual disabilities, and this is because their disability actually is presumed. There's a presumption that it causes them to be unable to testify in court. And I will focus secondly on people with victims of sexual assault. And the reason why I focus on victims of sexual assault is because the testimony of a victim of sexual assault is crucial in order to get a conviction in court. So generally, everyone is presumed competent to testify in court. But once a person's competence to testify has been challenged, the court must then ascertain whether or not that particular witness is competent to testify. And to do this, the witness is required to demonstrate an ability to understand the meaning of an oath or a promise. And secondly, the witness must also demonstrate an ability to recount the events to the court. So the application of the rules is such that the witness must define the concept of truth-telling in philosophical terms. And for persons with intellectual disabilities, this may be difficult to do. But this does not necessarily mean that they're unable to actually tell the truth. The distinction between an ability to define truth-telling in philosophical terms and the ability to actually tell the truth has been recognized in relation to the testimony of children under the age of 14 years. In 2005, the Canada Evidence Act was amended to abolish the requirement for children under the age of 14 years to define the concept of truth-telling in philosophical terms before they can be allowed to testify. So my research will be asking the question, do we need a similar provision with regards to persons with intellectual disabilities? This problem has been looked at and responded from in different jurisdictions. In Canada, for example, in 2012, the Supreme Court heard a case known as Crown versus DAI. And that case basically signifies that there might be a move towards doing away with the requirement for witnesses to define in philosophical terms what the concept of truth-telling is. And in Israel, legislation was adopted that actually abolishes altogether the competency assessments. So the way forward is that I will be looking at which is the best way to actually secure the right of access to justice for persons with disabilities, which is secured under the Convention on the Rights of Persons with Disabilities. Thank you very much.